Hello. We are talking today about a very, very good and very important way to end a litigation. We are talking about transaction. At least that's how it's called under the Civil Code of Quebec. The idea of a transaction is that it's a specific kind of an agreement. It's a document that gives each party who is going otherwise to the court or is already in some kind of a court dispute or litigation. This transaction is an agreement that puts an end to that in a way that it will prevent any further relitigation of the matter. So basically, a transaction, in this sense, it's an agreement that, if is signed by the parties, makes it impossible to continue to litigate the very same things, or usually anything which is like reasonably connected to that. So whatever were the claims of the parties to each other, based on particular facts and particular circumstances, when the transaction agreement is signed, there is no way to get back to court, at least in Quebec, about that. So it's not only that this court case is ended, but even later, if the parties change their minds, like years after, they will be still prevented from going to court again because of this document. And there is a third very important thing here, that a transaction, whether it was during the court litigation already or not, it can be homologated in court, ratified, if you wish, confirmed, in a way that this signed document, this transaction, can be presented to a judge, and the judge will order the party to follow, to obey, to abide by the terms of this transaction. So from that point, it's not only just an agreement between the parties, it's an order, a court order. And if any party does not respect that, then it will be not simply a breach of a contract of sorts. It will be a violation of a court order with all the sanctions that are connected to that. So if at any moment your negotiation, your mediation, any combination of those has ended with the other party, has ended in any kind of an agreement that at this point suits you both, it's a good idea to make a formal end to that conflict by way of a transaction, because this way you will actually have an end of it. It's like as much guaranteed as like anything could be legally guaranteed. And then you can just breathe out and make peace with yourselves, with just whatever the disturbance you had about that, and continue to move on to live your own life without ever thinking again about like what might happen, what could have happened, and so forth. This is why actually sometimes some commercial companies who expect some sort of an attack sometimes initiate this kind of a litigation, or at least a conflict on their own, envisaging a possibility to end it with a transaction, meaning that now, while not many bad consequences are already there, and while it's more or less hypothetical, at least like foreseeable only, there is a way to end this at the very beginning with lesser losses, let's put it this way. But well, that's another story. That's about legal strategy. So the tool, the legal tool, is a very important one because it helps you to be calm about the consequences, about the aftermath. It's sort of as close to a guarantee that this question will never come up again as it's possible in our like society, in our legal world. Thank you, and have a nice day.